Nothing at all, apart from the statement that the charges are bad for duplicity, has been told to you. In response, the charges before you are founded are on known provisions of the Penal Code, constitutional to say the least. None of them has been declared unconstitutional. And to that extent, you have proper charges based on the law, a law known in Kenya as required under Article 52 of the Constitution. Further, under Article 89.5 of, Section 89.5 of the Criminal Procedure Code, Section 89.5, yes, which is the only provision this court would invoke to reject charges. The only reason you could reject charges is that the charges do not disclose an offense known in law. Count 1 is founded on Section 89.1 of the Penal Code. Count 2 on Section 3 or 8.1 of the Penal Code. Count 3 on Section 511 as read with 510 of the Public Order Act. Count 4, which may be the newest of the charges, is under Section 4A of the Narcotic Drugs and Psychotropic Substances Act as amended in 2022. And finally, count 5 is brought under Section 771, which has been subject of constitutional litigation prior, and the court upheld that Section 773 is constitutional within Kenya. Similar to Section 5, which also has been subject of litigation and has been found to be sound. To that extent, you have proper charges before you. And finally, even if there were alleged, violations of fundamental rights and freedoms as alleged by counsel, then the only remedy would not be to reject the charges, but to seek constitutional litigation and damages before the High Court of Kenya under Article 165. Having said that, we humbly ask you that for good order, let us proceed to take the plea and then handle the issues arising after we've taken the plea. Thank you.
Allow me, Your Honor.
You are not too
over my colleague.
Let us have some water. I'll give you time. There's so much.
Does it make the presentation?
Yes, I want to add 2 points, Your Honor. One, all the 5 prosecutors appearing before you are duly gazetted to conduct prosecutions. And consequently, by virtue of that prosecution, that gazettement, they are properly before you, they properly approved charges and filed them.
This officer is harassing my client even now. He's receiving his medicine and he wants to take it away. I don't know what his problem is. This is medicine. You are not a doctor to confirm.
Let us have some order.
No, it's correct.
It's okay.
He has just received his medicine and it's being taken away from him.
We are the whole afternoon, dealing with one thing. We don't have other things to attend to. Let us have some order. If he has been given medicine to take, let him take his medicine. Why did you refuse him to take medicine?
His fellows.
Prosecutor, Mr. Moon, can you just tell the police if he has been told, if his drugs is taken and they are drugs, let him take his drugs, please. Yeah, it will be handled so that we finish this proceeding. Yes. We are sorry for that. You are gazetted. We urge the court to take judicial notice of such gazetting. 2, the office of the Director of Public Prosecutions is an independent office within the meaning of Article 248, 1 of the Constitution, which lists independent of 248 of the Constitution, which is a list of commissions and independent office. But you will note that the office of the DPP is not listed. But that article says, except to the extent this Constitution provides otherwise. So the question is, does this Constitution provide otherwise? The answer is yes. Article 157. Article 157 sub-article 11 provides that the Director of Public Prosecutions shall not be under the control or direction of any person or authority. This means he is independent, and that brings the office of the Director of Public Prosecutions within the purview of Article 248(1). So we are an independent office. Being an independent office, under Article 253 of the same Constitution, the office enjoys perpetual succession. The office enjoys perpetual succession, and consequently, the departure of Mr. Nuruddin Haji